Hello everyone, welcome back to my latest video. Uh, Today we are going to talk about divorce law. As is the modern trend, even in India now, the notion about marriages being forever is no longer true. Divorces have become more common now than ever because of differences between the spouses or other reasons whatsoever. So there are many laws in India which regulate divorce in India, and there are many legal procedures as well. The main one, court one, and alternate methods as well. So we are going to explore that further now. So moving ahead, when it comes to legal proceedings for divorce, there is a we are going to cover a lot of things. One, we'll first look into how divorce law has evolved through the ages on a brief scale. Then depending on what religion you belong to, there are personal laws that govern divorce as well. Then if suppose both the parties for some reason want to divorce each other, both of them have agreed to do so. So what is the what way they can do so with mutual consent? Then if one party doesn't want to divorce but the other wants to, so that one way divorce proceedings, how to go about that as well. Then alternate dispute resolution and mediation, which is often recommended by the courts, we look into that as well. Then all other sorts of reliefs, and what are the case laws which have shaped divorce proceedings in India over the years, we'll look into that too. Well, now how did divorce law in India come to be? From where did it origin, and how has it evolved over the years? You could say even centuries. So when it comes to ancient India, uh, back in the old days, especially in the ancient times, marriage was treated as a sacred bond. It was almost husband and wife were supposed to be together for life. That you couldn't exactly dissolve the marriage under any circumstances. But as it happens, so even in the ancient times, some exceptions were made. In ancient India, there were texts like Narada and Parashara Smriti. So they did permit dissolution, but only under very exceptional circumstances. Like if one spouse, usually the husband, if he abandoned his wife for any reason, such as during the old days, wars used to take place a lot, and men would often leave their families to go to war. So if he was missing for too long, then the dissolution of the marriage was permitted in those times. Or if the husband happened to be exceptionally cruel or neglectful towards his wife, then also, I'm emphasizing on husband because in the old days women didn't really enjoy many rights, almost none at all. Women were considered to be their husbands and husbands' families' property to do with as they wish. So if so usually the wife was usually any woman who was once married, she was completely bound to her husband and his family, almost like a slave, if you will. So again, it was whenever if any divorce or any dissolution of marriage happened, it was always presumed to be the husband's fault, since it was the husband who had the most power in those times. But later on, coming back from the ancient times, let's come forward now. So this not only in the ancient times, but you could say even throughout the Mughal era, also this kind of continued. So unlike the Hindu era, in the Muslim era, the women's rights, you could say women were objectified even more, so to speak. You have heard tales of emperors and sultans keeping more than one wife, almost like harems of women. So yeah, so again, women did not enjoy a lot of rights. Then moving forward to the colonial era, in 1869, the British implemented an Indian Divorce Act. However, since the British were Christians, in the initial days of their rule in India, they did not focus too much on the Indian communities. See, what happened was when they first came to India, the British East India Company, they had suffered tremendous losses in their American colonies. They had been forced to give independence to the what was then the 13 colonies. So the British, and it was largely believed this was because the British intervened too much in colonial affairs. So even though the British came here to India to govern and rule, their primary aim was to extract our resources. So they did not, so the way they saw it, the key was to establish a peaceful, quiet rule of their colonial subjects, which meant not interfering too much in their affairs. So this Indian Divorce Act, it was primarily meant for governing divorce among the Christian communities. Basically, those whom the British could convert to Christianity, or in minority cases, people who had already been Christians in India long before the British came. But mostly British converted Christians. This law primarily applied to British governed Christians. However, later on, the British did start to intervene more and more in Indian affairs. So, moving forward to 1939, the Muslim Marriages Act, there used to be a Muslim Marriages Act as well, which governed marriage and divorce among Muslims. So this act was, so, oh sorry, let me correct myself. In 1939, the British went on to institute a Dissolution of Muslim Marriages Act. they want they largely viewed the Islamic community as pretty backward, so they wanted to, in a manner of speaking, progress the Muslim community further. So they instituted this act to empower, to govern divorce among Muslims properly. You could say, in particular way, to empower Muslim women further. So this act, what happened was, it laid down certain grounds. See, before this act, apparently the Muslim community was left undisturbed, but women in that community have been pretty much marginalized. They were not given proper rights. They could be divorced, or they could even be cast off as per their husband's will and desire. So in order to institute some measure of progress in the Muslim community, the British instituted this act wherein Muslim women were empowered. They were given specific grounds by which they could legally seek divorce in the British courts, or in whatever legal system the Muslims had in place. Then later on, after independence in 47, in 54, our Indian government instituted a special marriage act. Now this act, now after independence, our government put a secular foundation for the Republic of India, meaning as per them all religions were meant to be equal in the eyes of law. So this act was made to govern marriage and divorce among, you could say, interfaith marriage and divorce. Like people of different religious communities could marry amongst each other, and they could even divorce properly if they on certain grounds, and irrespective of what religion they belong to. For interfaith unions, this act was formulated. Then a year later, in 55, along with other Hindu reform laws, this Hindu Marriage Act was also instituted. This introduced divorce specifically for members of the Hindu community, which, as per our Indian constitution, includes the mainstream Hindus and also other branches of Hinduism, namely Jains, Buddhists, Sikhs as well. Now that we have covered the chronology of divorce law, moving ahead, let's cover briefly the diverse framework of divorce law. So one thing we need to understand is, when it comes to marriages and divorces, every religious community has their own rules and regulations. You could say their own personal laws governing that community. So number one is the Hindu law, or the Hindu Marriage Act, as we talked about earlier. Then after the Hindu Marriage Act, then there are other Hindu laws also. This governs the mainstream Hindu community, as also, like I said, other branches like Sikhs, Jains, Buddhists, all of which historically have spawned from Hinduism. So this Hindu Lloyd incorporates various grounds. We'll cover those grounds later on. Then number two is the Muslim law. It is governed by the Sharia law. The Sharia law is a historical law which has governed the Muslim community ever since Islam was founded in the 7th century. And and also the British formulated Dissolution of Muslim Marriages Act. So this Muslim law, it covers the judicial pathway as well. Like if you want to get a marriage or have a divorce, then how to go about it via court, and also extrajudicial, as an alternate means other than courts. Then next is there is the Christian law. Like I said earlier, the British formulated Indian Divorce Act 69 was formulated primarily for the Christian community. Since the British are themselves Christians, they were more focused on regulating the Christian community at first. They didn't move on to other religious communities, but that was much later when they felt more secure in ruling India. So this Christian law, this Indian Divorce Act, there are specific grounds for divorce which are covered under this act, namely adultery as in if your husband or wife is having an affair with another person, then that's adultery. Then desertion, that is if for no good reason or without any reason at all your spouse deserts you for a very long time. In our as per Indian law, it usually is about 7 years or so. It could be lesser also, depending on case by case basis. So these are the two grounds which Christian law governs. Then there is the secular law. Like I said earlier, our constitution is very firm on secularism, as in equality of all religions. So the Special Marriages Act is this secular law which provides a uniform divorce route for all religions, especially if if you and your partner are of different religions altogether. This is the act for you. Now moving ahead, when it comes to Hindu Marriage Act, for those of you who are Hindus, the vast majority of us, so the section 13 of this act provides the grounds, very comprehensive grounds for seeking a divorce. So what are the fault based grounds, like as in the fault of one party that this divorce proceeding is happening. So number one is cruelty. That is this happens too often in Indian homes, and also homes abroad as well, where one spouse who is in a particular position of power, usually men, they often physically abuse women, like beat them up, or sometimes even mentally abuse them. Mental, physical, emotional abuse also a thing, where they consistently insult them, denigrate them. So what happens is the other partner, the victimized partner, feels dissatisfied, or physical abuse causes them to be significant, suffer from wounds all the time, or be in danger all the time, which may not really a good grounds for a sustainable marriage. Then desertion, as in if one spouse abandons the other for a long time without really stating why he's leaving, like anything, like he doesn't really bother explaining, or he just disappears just like that, vanish in a puff of smoke or something. For desertion, if you want to seek a divorce for desertion, the minimum period of time for which your spouse should have left you without any reason must be at the least 2 years. If 2 years are passed, only then you can file a petition for divorce, or you can seek one. Now, before I move further, when it comes to cruelty, I must state that while historically it has always been men abusing women, of late, even women abusing men has become a ground now. False cases, false rape cases, or for other false cases which are designed to take undue advantage of even good men, is also a thing now. So this thing could apply vice versa as well, not just man to woman, but also not just woman versus man, but also man versus woman. Then next is adultery. Like I said, if your spouse is having an affair with another person, um, without your consent, obviously it's without consent, that it goes without saying. So this is usually the very common ground of divorce, adultery. Uh, you catch your partner having an affair with another, then you can seek divorce, no matter what. It's usually a very common ground. Other common ground being cruelty as well. Sometimes if your partner has power over you, but he or she user often misuses that power to abuse you. That is also a ground for divorce, like you could say second most common ground. So under, when it comes to Hindu Marriage Act, what's other ground? Now these are fault based grounds, as in it being the fault of another party. As in you could say common grounds, usual grounds, not exactly something laid down by law, but something which happens most of the time. Now there are, however, statutory disqualifications as well, as in as per the law also you could seek a divorce if the law itself lays down those grounds. One being, if your partner has somehow decided to convert to another religion, like if your partner is a Hindu but he decides to convert to Islam or Christianity, that is also one way to seek a divorce. Then if he or she decides to renounce the world and go into the forest to meditate and all, this used to be a thing in the old days, but now not so much anymore. Nowadays it's all about fake sannyasis. So of course I suppose even false renunciation could be a ground as well. Then mental disorder, if your partner is somehow rendered insane for any reason, like if he starts to behave strangely, and if you take him to a psychiatrist and he deems him insane or her insane, then that the law permits you to divorce on that ground as well. You don't have to be his or her caretaker. You could divorce if you want, and you no need to take the burden on yourself. Now moving, now that was Hindu law. When it comes to Muslims, there is a way to divorce your partner if you are a Muslim. There is a law that provides for dissolution of marriage between Muslims as well. So one is now this law was laid down in 1939 as the Dissolution of Muslim Marriages Act. With this act, first of all, provided for the judicial rights of women. Earlier, before this act, especially Muslim women, they were treated as primarily property to be used by their husbands as they saw fit, meaning they could mistreat them, abuse them, or even beat them as they saw fit, and the woman couldn't do a thing about it. But this act empowered women to seek a divorce if they are mistreated by their husbands in any manner. Namely, if their husbands neglected them in favor of other women, or if their husbands treated them very badly, like cruelty and all. Then there is unfortunately, when it comes to men, or rather fortunately, depends on point of perspectives. So husband also have got the rights to initiate a divorce proceedings to simply repeating the word talak 3 times. Historically, the courts didn't have to intervene, couldn't do anything about this. They couldn't intervene. All a husband had to do was say talak 3 times, whether it be instantaneously or within a couple of months, and the divorce happened without the woman able to do anything about it. However, when it comes to talak, this power has been thankfully curtailed by the courts through the years. So now that in 2019, a special act was formulated by the Modi government, which abolished the use of instant triple talak. This was a malady that pervaded the Muslim community, especially Muslim women, wherein Muslim women often receive WhatsApp messages or SMSs stating the word talak 3 times, and the divorce happened, and the woman couldn't do anything about it. Thankfully, the Modi government initiated this law, which abolished instant triple talaq. However, the practice of triple talaq still goes on. Maybe there might be some reforms in the future, but it remains to be seen. Like that the talaq being stated once a month or something over a period of 3 months and all, that still continues. So maybe there would be reforms, but like I said, it remains to be seen. Then financial settlement. Well, now there are two words which come to mind when it comes to financial settlement in Muslim law: meher and iddat. Meher means that it relates to certain property that a woman receives from her husband at the time of marriage or afterwards. The woman has the full right to keep that property. She has full ownership of that property. Not even the husband could touch it. Then the other is iddat. Now this is a restriction on women. Once a divorce happens, for at least 3 menstrual cycles, or usually after divorce, or if the husband has died, about 4 months 10 days after the death of the husband, the woman is prohibited from remarrying. You could say it's kind of like how historically widows were treated in Hinduism, that if the husband died, then the woman was obliged to shave her head and live the rest of her life as a sannyasin, prohibited from remarriage forever. Except here it is just a couple of months or days, but it's still a serious restriction. Now moving ahead, when it comes to Christians or Parsis, there are divorce grounds here as well. Now obviously in Christian cases, it is the Indian Divorce Act, the British formulated one. So what are the primary grounds for here? Again, like other laws, like as I said, in Hindu law, it is usually having an affair with another person outside marriage, then abuses endured by you under whatever spouse you are living with. Then if your spouse has left you for no good reason or without any reason, all these are primary grounds. The wait period when it comes to desertion, just like in Hindu law, here it is at the least 2 years after he's left you. Then when it comes to Parsi Marriage Act, this act governs marriages and divorce between Parsis. The three grounds again being: number one, mental, physical, emotional abuse and cruelty visited upon you by your spouse. Then your spouse having an affair with another person. Then if he or she is rendered insane or is declared insane by a certified psychologist or psychiatrist. Then when it comes to the wait period for before initiating divorce proceedings, this depends on the law. Then however, in both these cases, when it comes to Christians and Parsis, the wife does have very special rights. Like I said, in the olden days, women were often marginalized and treated as property without rights. So in the modern era, they have been given specific rights, specific powers to dissolve marriages whenever they want. So these two grounds are bigamy. Now, unlike certain religions like Islam and Hinduism, Christianity, Parsi religion, the having more than one spouse is not allowed. When you marry, you are only supposed to have the one. If you want to marry another, you'll have to divorce the first one. So bigamy, marrying another person while you're still married, is definitely a valid a ground for divorce, a definite immediate ground for divorce. Then incestuous adultery. This is a little strange. Incestuous would mean affairs between members of family. It's a bit gross, but in the old days it used to be a thing. Especially this might be an astonishing fact, but in ancient Egypt, pharaohs often used to marry their own sisters, if you can believe it. Yeah, it was that bad. So affairs between siblings or between members of other immediate circles of members, what we call incest in short. Incest is definitely a ground for divorce. Most families don't do it nowadays. It's just gross. In the old days, it used to be a thing, incest. Like I said earlier, um, And those of you who are Game of Thrones fans would know about the Lannister incest between Cersei and Jaime Lannister. It is pretty much the plot point of the whole series. But of course, we are not going to use fictional examples here. Let's stick to real life ones. So when it comes to more than double marriages or more, or affairs between family members or siblings or other close members, those are immediate grounds of divorce, no waiting period. Then when it comes to Special Marriage Act, now this is, like I said earlier, a secular pathway, particularly for the interfaith marriages. If you and your spouse belong to different religions, the Special Marriage Act is the one for you, should you want to divorce for any reason. So the standard grounds under this act for cruelty, it's very similar to the Hindu law, namely adultery, cruelty, and desertion, same as the Hindu law really. Then if it also, this act also provides for mutual consent, like if you and your partner are living together for a while and you had differences and you have been unable to resolve them and reached to such a point that you couldn't live together anymore, so you want to divorce, like you want to separate, and it is by each other's consent, you agree, he agrees, he or she agrees, and so this act provides for that mutual consent as well. So when it comes to mutual consent, there is a timeline for this. So before you initiate divorce proceedings, if you and your partner, because of your unresolvable differences, have agreed to separate from each other, live separately, you must have lived separately from without any contact with each other for at the least 1 year. Yeah, you must have had a 1 year period from the date you were separated, and you must not have had any contact with each other during that period. No resuming sex or anything, and as in no sexual contact or anything. So that is the minimum period. Then there is a cooling off period after that. Once the proceedings are initiated, once you are separated, you need to wait for a minimum additional 6 months mandatorily before you start, as in when you after 1 year, when you start to file a divorce case, you must settle it within 6 months minimum. Then there is a maximum period also, which is about 18 months. So basically within 6 months you file one divorce case and that is not successful, you are given more time, max 18 months, within which you could file a second or more divorce suit. Then so when it comes to mutual consent, there is a detailed procedure. So if you and your partner have been living separately for you could say the next at least a year or so, as I said earlier, then you can file a petition in the family court where you are staying. As a family court, in the wherever you are staying, you can go file a petition in the nearest family court for divorce, stating that you have been separated for at least a year or more, if it is more, and why you cannot live together, why it is impossible to reconcile. Then later on, after the court receives the petition and takes it into account, there is a first motion. So namely, not just the other party, but not just you, but your spouse also would record his or her statement before the court. Then later on, after those statements are recorded, the judges, whoever is in charge of the case, would call upon both parties and hear both of them out and confirm the contents of the petition. Then the court would not exactly complete the case as well. Nowadays what happens is most family courts, they believe that since divorce has vast consequences not only for the partners but also for other members of the family, and particularly if both of them have children, divorce often has a negative impact on children. So the court usually wants the parties to reconcile first, or at least attempt it at first. So usually after the case is filed, the court directs you to a reconciliation venue, or mediation, you could say, where the court orders the parties to work out their differences first. So for this, it is a minimum period of 6 months. It sometimes even extends to max 18 months, as I said earlier. During this period, the spouses have to converse with each other. They have to turn up at the reconciliation venue, work out their differences as much as possible, if they can. If they can, good. If not, the next is a second motion, where the parties would appear before the court again and reconfirm their divorce decision. That no, there is no reconciliation point. The differences are too big, too vast to ever be reconciled, and that divorce is the way to go. This is about the second motion. So after this, the court, just like any other case, the court would ask for evidence of differences, or evidence of any bad stuff that's been happening in between the partners or in the family, which would have caused this divorce proceedings. Once the court verifies all that, along with any witness testimony and all, then last step would be the court grants a final decree of divorce, where declaring both the parties separated and any financial settlements between the parties to be done, and so on. Now moving ahead, now this is mutual consent divorce, that what we said earlier. It's since it's mutual consent, so it's not it is a hassle, but not as much. Now this is about contested divorce. Now what's the difference between contested and mutual divorce? Mutual divorce is both the parties have agreed to divorce. Both the parties agree that there is no point staying together, so let's separate forever. Contested divorce is where one party is aggrieved and the other party is at fault. Kind of like a criminal case, where one party commits a crime, the other is the victim. So here the victimized party is the one who wants to divorce because he or she cannot stand it anymore, or he or she is suffering in the marriage and really wants to separate. So he or she files a petition before the court seeking a divorce. However, this contested divorce poses a lot of problems that mutual consent one doesn't have. Number one, the victimized party, he has to provide sufficient evidence and grounds for divorce before the court. Just like a criminal case where once the defendant is put on trial, the victim or any witnesses in testifying on behalf of the victim have to provide a solid proof of the crime and all. So here also the victimized party has to prove evidence of the other party's negligence or cruelty or anything before he can seek a divorce. Then just like in criminal cases, the defendant party or the respondent party, he has the right to hire his or her own legal counsel or lawyers, and he has the right to defend himself in the court through such counsel, just like in a typical criminal case. Then just like in criminal cases also, here the trial goes on for a long time, lot of complexity, summoning witnesses, taking into account all available evidence, taking into consideration which evidence is relevant and admissible, which is not, then arguments going on between the legal counsel of the victim and the defendant, and so on. It's just like criminal cases, contested divorce can be very complicated. So again, it's better when it comes to contested divorce, it's best to prevent this by checking out what is the character of your partner before marrying. But of course, this isn't possible all the time. So if you are going for a divorce like this, just be prepared for a long legal battle. Or better yet, seek alternate measures. Now ahead. First, usually now whenever a divorce case is filed in any family court, the family court usually asks the parties to go to a mediation center wherein a mediator is appointed, and that media either by the court or by the parties themselves. If the parties want to appoint it, then the parties try attempt to work out their differences with such mediator. If it doesn't happen, then the case goes back to the court. Now these are all this in 2023. India introduced the Mediation Act, formalizing mediation as a dispute resolution mechanism, not just for divorce cases but also for commercial cases and other cases. Obviously, criminal cases like murder or fraud or anything, the mediation doesn't cover those. That's a full criminal trial in a court. Then other general facts, namely there is a mediation center at Bangalore where out of 30,000 cases registered there, over 20,000 have been settled successfully. Then so yeah, it's a this although it is only one mediation center, it is still Bengaluru, which is one of the major cities of India. So it's still a pretty big sign that mediation is fast becoming the one of the most sought out methods for dispute resolution in divorce, in commercial disputes, and so on. Now when it comes to mediation as a dispute resolution method, there are many benefits. Number one, if both the parties are press averse or press shy, they really don't want the proceedings to be publicized in any manner, but they want to keep it strictly private between themselves. Mediation allows for such privacy. The mediator will promise to keep the divorce proceedings strictly confidential and only to refer it to the court which send the parties for mediation should the occasion decide. Then number one is child welfare, especially if marriages have lasted very long and you had children out of the marriage. Divorce can affect children very negatively. Children need both parents for stable development, for a stable happy childhood. So if the parents separate and all, this has a very adverse effect on children's mental development. Children could be traumatized by this. So mediation helps parties to work out their differences, and even if they can't work out their differences, at least attempt a course of action in such a way that the children's mental health is not badly affected, that the children still get to enjoy a, if not a very happy childhood, at least a reasonably happy one. Then this is also very efficient, and a full-scale trial by court usually involves witnesses, documenting evidence, and it goes on for months, not just months, sometimes even years. So mediation, by contrast, happens within a couple of months at the most. So this is much faster, and because it isn't so public, so the parties really just want to get it over with as fast as possible. So again, and because it is at the party's own will, they can decide the amount of expenditure that goes into it. So it's also cost efficient. Then when it comes to a trial before a court, first of all, the judge is not appointed by the party, so no, they don't know what sort of judge will be most suitable for this case, or they can't really influence the outcome the way they want. But in mediation, the parties can mutually decide what sort of outcome they would like. They don't have the restrictions that a court trial would have normally. So when it comes to divorce proceedings, there is a thing called alimony maintenance, as in the other party seeks maintenance, at the aggrieved party seeks some sort of financial compensation or benefit from the defendant party. So there was a case that established this in detail. One was this was Rajneesh versus Nya. So what did this case establish? Number one, it is the duty of the defendant party to disclose the full extent of his property and assets which could be used to pay maintenance to the aggrieved party in the divorce case. Of course, the aggrieved party has to file a affidavit as well regarding this aspect, because it happens that there are cases filed where the aggrieved party is not totally aggrieved. He or she has the means and the capability to earn on her own, and she's seeking unnecessary benefit from the from the defendant party as a form of vindictive justice. The courts usually aim to prevent this sort of vindictive justice, so that they require for affidavits from both the parties to this effect. Then this now coming to Rajneesh versus Neha, what happened was the aggrieved party Neha, she had left her husband Rajneesh on grounds of cruelty way back in 2013, and she had filed a petition before the family court here in Mumbai. So the family court had ordered the husband to pay rupees 15,000 and additional rupees 5,000 monthly as well. So what happened was uh, the the husband was not happy with this, so he took the case to the Bombay High Court, stating that the Bombay HC is not saying that he didn't have enough income, enough money to pay the maintenance to the wife. The Bombay HC, however, upheld the order in favor of the wife, so the husband took the case to the Supreme Court. As it happened, even the Supreme Court upheld the order in the end, so the husband didn't benefit either way. So that was the one guideline. The next guideline which this case established was if the order for maintenance is passed, from which date it takes effect. As it happened, from the date the aggrieved party filed the petition in the court, you could say the family court, the first court where she filed the petition. From that date onwards, the maintenance order was to take effect when she became successful in her suit. Then it also emphasized that even after the divorce, it was the duty of the defendant party, if he had traumatized and abused his wife or other spouse very badly, to ensure that she lived as she lived when she was married, that she suffered no severe disadvantage whatsoever. So essentially, it fixed maintenance in such a way that she would be able to live just as well as she did at the time of marriage. Now, when it comes to maintenance, there are several ways by which maintenance could be provided. One is interim. Interim is it usually means for support. When a divorce trial is taking place, then if a divorce trial is taking place and a court decides that the aggrieved party is in dire straits and needs urgent financial compensation, the court could pass an order directing the respondent party to pay the aggrieved party some amount immediately. Then there is the other called permanent maintenance. This is of course after the order is passed, after the case is concluded, after a decree is passed. Then after this, the court affixes either a lump sum payment or a periodic payment which is to be paid by different to the aggrieved party after everything is said and done. Again, there is a section 125 of Code of Criminal Procedure 1973, which is a secular provision. In this provision provides for maintenance of an aggrieved spouse by the defendant spouse, usually husband, maintenance of wife by husband, and this order can be done by this case is usually decided and provide the maintenance order passed by a magistrate of the first class in the jurisdiction where both the parties reside. This provision is for all religions. There are no distinction between religion of any kind in this case. Okay, so moving ahead. Now, initially when it came to divorce, courts used to emphasize on rights of the parties, or in case it was a complete family with children, rights of the parents. However, nowadays the courts have decided and have come to realize that the children's welfare matters just as much, probably more than the parents'. Since children, they don't really understand what's going on, and sometimes they suffer greatly because of through no fault of their own. They are the real victims most of the time, because children need both their father and mother to have a happy childhood for stable growth and mental development. So if divorce happens, they suffer the most. So there are So how does the court prioritize children's welfare in such cases? One is the custody model. So what happens is the when it comes to divorce proceedings, there are many types of custody the court could have. One is sole custody. If a court through the in the case of a divorce decides that one party is particularly unsuitable for parenting or is very cruel or negligent, that he or she is not fit to look after the children at all, so the court may award custody of such children to the other parent, to the other party. Then there is joint custody. Joint custody would be where one party, both the party, the children of both parents, the court may decide that the children would stay with one parent for a specific period of time. Let's say within a year, let's put it half by half. The court decides that the children would stay with their father for 6 months, then after the remaining 6 months of the year they would spend it with the mother. So that's why you could say is joint custody. Then however, if he does not however, in cases of sole custody, there is if the other parent is not awarded custody but he wants to visit his or her children from time to time, so there is a thing called visitation rights. The court would establish that would permit the non-custodial parent to visit his or her children at specific intervals, like once a month or once in 3 months or anything. So there is the so this is the models for custody. Then there is also the welfare principle. Whenever the court awards decides a divorce suit, it takes children's welfare into account. Namely, it takes into account child's age. Like if the children are very small, like say below 7 or below 5, obviously they suffer a lot and they can't even comprehend why they are suffering. So the court would decide that. Then the court would take into account the nature of both parents, find out which parent is most suitable at looking after the kids, and on the basis of that decide the custody matter. Then education. If a child likes a particular school he is in or a particular place he is staying at and wants to stay there, the court would decide custody on the basis of where the child could get the better education or where the child likes to stay. Then he would also decide the child's psychological well-being, as in where the kid is happier, at which place or with which parent he is happier, most satisfied. Essentially, it's not usually in most cases the courts feel that a parent having more money is more suitable to look after their children, but the court would probably take the children's testimony as well and find out if the child is happy if with even a poorer parent, then the poorer parents would get to keep the kids, not necessarily the richer parents. Then usually if a divorce case is going on for a very long time, the courts would often grant temporary custody, as in just like how there is interim maintenance, so here also the courts would order for the child to stay with a particular parent if the court feels the other parent is inherently more dangerous or more unstable for the to stay until of course at the end of the case the whole thing could be reversed, but there is this thing called interim custody. That's all to say. The number one, there is a thing called property, unlike now in the West, divorce has always been pretty common, and it's becoming common in India also as well, more due to Western influence. However, in the West, there is a thing called 50-50, as in both the parties contribute to each other's financial settlements in a way. One party gives his share, the other party gives his or her own share of the married property. It's equal. However, here in India, it is not so. Here it is based on how much property you own and how much you have contributed to the overall property at the time of marriage. So what this thing is, now there are three ways we must take into account. One is marital property. Like I said earlier, This is property that was built by both the partners together during the time of marriage. Now, at the time of divorce, this property is subjected to division, but not 50-50. It depends how much one party has contributed to the building up of that property, both financially as well as non-financial, as in kind, like how much effort he or she put in, and so on. So on the basis of that, the court to decide the percentage of division. Then Hindu law provides for a concept called Stridhan. Now Stridhan is when a woman is married into a family, the groom's family and the groom and his family, they provide, and even the bride's family for that matter, they provide gifts at the time of marriage, either not just at the time of marriage, even before the marriage, like during the engagement and all, or even after marriage, there are gifts that are provided to the wife. Those gifts, financial and non-financial, usually this is financial only, like money, jewelry, and so on. And this is the sole prerogative of the wife. Like this is the sole property of the wife. Not even the husband cannot really touch the stridhan. He cannot touch the property of the wife in any manner, unless and until it is a very dire matter. So at the time of divorce, stridhan helps the wife a lot to to sustain herself financially. So those of you who are women, if you are seeking a divorce, make sure you have accumulated a significant amount of stridhan. It could help a lot when you decide, if you decide to ever divorce your partner. Then when it comes to shared household, usually in the olden days and even to some extent nowadays, what happens is when the wife when a divorce happens, the wife who is staying with her in-laws is often kicked out of her in-laws' house, and if her parents are willing to take her in, good and well and good, but otherwise it could happen that she is destitute and left on her own. So the Supreme Court in this case, called Satish Ahuja 2020, established that when the divorce proceedings is going on, the wife must be allowed to stay in her husband's or in her in-laws' house. She cannot be unjustifiably thrown out. Then there are many judicial precedents set up which have helped evolve the divorce law over the course of years. These cases have laid a firm foundation for the divorce law as it exists today. One is Savitri Pandey 2002. This case it primarily impacted the breakdown of marriage. So what happens is, what this case resulted in, it happens sometimes that in case of contested divorce, the victimized party, sometimes he may or she may not want divorce at all, but the other party, because he wants to marry a better looking woman or he sees more financial benefit, he insists on divorce and he tries to aggressively seek it even against the other party's consent. So this case established that the other party's claim alone would not be enough for dissolving the marriage. The other party must also seek divorce, must agree to the divorce, or must at least be okay with it. Then years later, there was a case called R. Srinivas 2019. This established for Article 142 to be applicable to this. Now, what is Article 142? Article 142 is there is a law provision in this constitution which establishes for the court sometimes overlooking the established provisions of law to render justice. So what happens is, if there is a particular type of case going on by which the court feels that justice ought to be rendered to the aggrieved party, but the established legal provisions applicable are not really suited for it, then the court can overlook those principles and provide justice to the aggrieved party if the case really warrants it so. Of course, this article has restrictions to ensure that extrajudicial justice is not unnecessarily implemented. You could say this article should not result in unnecessary legal vigilantism, so to speak. that the established provisions of law must be respected. Only in very exceptional circumstances can they and should be overlooked. So what was the key takeaway from this case? The key takeaway was, this case, the divorce was granted on irretrievable breakdown. So what happens is, there is a new provision established in the Indian law which says that despite all attempts at reconciliation or any way to resolve differences, if the marriage has broken down in such a way, if the parties are living separately for years and they are not able to reconcile at all, that there is no way to resolve differences, then there is no option but to grant divorce. So this case established that divorce is necessary if the marriage has broken down without repair. This irretrievable breakdown as a ground was further buttressed. Uh, Even before this, there had been a case called Nilu Kohli 2006, which had established this irretrievable breakdown as a new ground for divorce. Then, like I said earlier, the latest case, Satish Ahuja 2020, established the wife's right to stay at the husband's and in-laws' house during the divorce proceedings so as not to be unfairly disadvantaged in any manner. So as to disable the husband and his in-laws from taking any sort of vindictive revenge or anything. Illegal revenge, so to speak. Then the obviously divorce law, like every other law, is constantly changing from time to time, depending on the legal land other and social landscape and so on. So before the era, so there is this, historically there has always been a focus on victimized party and defendant party. There's always been a case where one party has to prove the other party guilty of any ground of divorce, namely cruelty, desertion, or adultery. So then that has always been historically the case, so it's not nothing new. Of late, the Supreme Court has also been using Article 142, as I said above, namely, if the marriages cannot be dissolved as per the established provisions, the court has full powers to overlook those provisions and establish divorce based on the existing circumstances, essentially to overlook the established law itself. As I said, however, the court takes care to exercise this law only in specific cases so as to prevent abuse of authority and legal vigilantism. Then there is an ever since the cases of 2006 and 19 as explored earlier, the irretrievable breakdown, that is uh, the marriage being broken down beyond repair, beyond hope, no hope of reconciliation at all. So this irretrievable breakdown has been increasingly been established as a new ground for divorce. This is now emerged as a perfectly valid ground for divorce. Of course, the court will decide it case by case. It does not mean that irretrievable breakdown can be used as a ground for divorce every time. The courts or mediation centers and all would take the whole facts of the case into account before deciding this as a valid ground. So you can't just use this howsoever you want. The judicial system has placed restrictions on this new ground of divorce as well. So what are the best practices for, so if you are so when it comes to all of us, the general public and all, what is the best practice for those of us who are seeking a divorce? What is the best legal way to dissolve a marriage if your marriage is unsatisfactory and if you are suffering in the marriage? So number one, you have to, whenever you go to a court, the courts will almost always emphasize mediation. The courts will usually, I have went to the Bombay High Court several times in family law, in family court, and I have seen that judges usually ask the parties to go to a particular mediation center or a mediator to resolve their disputes. And this is perfectly good because court trials take an inordinate amount of time and money. So if the parties are suffering from trauma, or they are not irreconcilable but want to reconcile, then the mediator would help them to do so quickly and efficiently and on their own ground. The parties can even decide on the grounds of reconciliation. They can resolve their differences quickly, immediate, quickly, without paying too much money, and also privately. Unlike in for court cases where you would have the embarrassment of having the public view your trial, in mediation it is completely private. And the mediator, while the court usually appoints a mediator, the parties could also appoint a mediator of their own choice. So again, you have, as when it comes to mediation, you have full discretion on how you can go about this. So even if you do want to file a case in court, first seek mediation. That is my advice. Then if the mediation fails and there is no choice but to file a divorce case in court, ensure that you maintain a full written record of whatever assets and liabilities you have maintained. In fact, if you are married, it's best to ensure that your husband or wife, whoever it is, he or she maintains a full record of how much property she has, what is the value of that property, how much balance is there in his or her bank accounts, how much physical cash is there, if he has any jewelry or any other monetary assets or non-monetary assets, a full inventory of that list of assets, and also debts as well. If there are any possible debts which could impact the amount of assets you have, or impact the amount of maintenance that could be provided to you in the event of a divorce. So a full disclosure, it is necessary to maintain a full inventory of that. Make sure your spouse maintains it, and make sure you as an aggrieved party also maintain it, because Rajneesh versus Neha established that this and after Rajneesh versus Neha, the courts usually require affidavits from both parties, and listing a full inventory of all assets and liabilities. If you do not maintain a proper list, or if the list are in the list, if you have omitted a particular asset for any reason, like you want to make profit, or you do not want to have to pay the other party, well, if the court finds out, it could impose very severe legal penalties. Sometimes, in fact, as per section 145 CRPC, if the party doesn't pay maintenance properly, he or she could even be subjected to at least a month's imprisonment. So make sure that if your case goes to court, you and your defaulting partner maintain a proper record of whatever assets you have, whatever debts you have accrued over the years, and submitted properly to the court. Perjury before a court often results in imprisonment, severe penalties, fine and imprisonment, and also make sure to maintain a good record. Then when it comes to contested divorce, it usually happens in, like I said, if your partner is abusing you badly, or if he or she maintains um, has left you for no good reason, or and it has happened for at least 2 years, like I said, or if he or she has not conducted himself properly financially, if he or she has accrued unnecessary debts, or irresponsible investments have been made which have resulted in near bankruptcy or a considerable drop in financial standards of living, then you must maintain a proper record of all those misdeeds. Maintain a proper, you could say, if when it comes to physical cruelty, you could make sure to keep a secret camera in hand where you could have the deed of cruelty or the abuse recorded as video evidence. Or when it comes to desertion, you could maintain a written promise, a record of a written promise, where the husband or wife had promised to return but he hasn't. So you could show that written evidence before the court. When it comes to financial misconduct, maintain a record of that investment. Find out how much was invested, whether it was necessary to invest that much, and how much has accrued, how much returns have accrued to you. And if you lost the entire sum of money because of your partner's irresponsible financial behavior, then how it has impacted you. Maintain a written record of all that. and submit the written records before the court. Usually written evidence is what is usually admissible. Courts lay more emphasis, they regard written evidence or recorded evidence as more proper, more reliable than oral evidence. So just to put it in short, maintain a record of everything that goes on in your house, whether it be cruelty, whether it be financial irresponsibility, or promises to return back home but not done so and all. So maintain a record of all of that, written or written or video record or audio records or anything, so that when a case comes for divorce you can submit it all as good evidence. If you hired a lawyer for this, it could help your lawyer as well. So just to conclude this video, as I was so as I said earlier, when it comes to divorce law, it's better those of us who are members of the general public wouldn't understand divorce law all that much. So I hope this video has helped you all to understand the various provisions of divorce law that are prevalent in India, whether it be religion wise or ground wise or anything. So if you want to achieve a fair and a legally sound dissolution, as in a dissolution of marriage or divorce which would stand the test of law in any legal forum, it is better to try to understand the divorce provisions prevalent throughout India. Or better yet, seek a legal professional who understands how to conduct divorce proceedings pretty well. So the focus should be first of all on mediation, as in if you are before going to a court, it's best to seek out a mediator of your own choice who will help you to resolve your marital issues pretty quickly without a messy court trial. Then if you have children, make sure that if you are conducting a divorce proceedings in any way, that the children are not adversely affected in any manner. Then when you go to file a divorce case in court, make sure you understand all the legal provisions affecting your case pretty well, or seek out a legal professional who can represent you in court in such cases or educate you on these provisions. Better yet, my advice is, those of you are general public members, not lawyers and all, just seek out a lawyer of your choice who can understand all this pretty well. So I thank you all for watching my video. Those of you who are general public members, I hope you have understood the provisions of divorce law pretty well from this video. And those of you who are lawyers or other legal professionals, particularly divorcees, I hope this video helps you all to recap your memory of what you learned in law school, or this video assists you in your daily work. Please do subscribe to my channel at siddharthbut4898 in order to watch more of my videos regarding legal matters. I thank you all for watching this video, and I hope it helps you to refresh or enhance your knowledge. Thank you all. Thank you.